Foundation, it is my absolute pleasure to welcome you all to today's seminar. We are thrilled to see so many of you here today, demonstrating the growing need to understand and address critical consumer issues. Before we proceed, let us extend a warm welcome to our speaker today, Mr. Jehangir Gai. May I request you to please join us on stage. Can I ask my colleague, Libertina, to please welcome Mr. Gai with the bouquet of flowers? Thank you. Today's topic is one that touches nearly every household, health insurance. Many of us turn to health insurance as a financial safety net, reassurance in times of medical crisis. However, navigating the system can feel like an uphill battle, especially when faced with claim rejections, unclear policies, and procedural roadblocks. This seminar aims to empower you with the tools and knowledge to decode these complexities, understand your rights, and to take action when things don't go as planned. It is only fitting that we have Mr. Jehangir Gai here to guide us through this. So, Mr. Jehangir Gai is one of India's most respected consumer activists with an illustrious career spanning nearly 4 decades. As a freelance columnist, his incisive and practical advice has graced the pages of leading publications such as Times of India, Business Standard, Indian Express. His Q&A columns have served as a lifeline for countless consumers, helping them navigate grievances and win rightful claims. Mr. Gai has also been part of a consumer movement since 1984, even before the Consumer Protection Act came into force. His relentless advocacy has earned him the National Youth Award for Consumer Protection from the Government of India. Over the years, he's argued landmark cases in consumer forums, including a pivotal ruling allowing telecom disputes to be filed under the Consumer Protection Act, a victory that was upheld by the Supreme Court. His work extends beyond consumer issues to the right to information, where efforts have expanded the scope of transparency for public authorities. He has also filed public interest petitions and appeared before public forums and courts to address systemic issues in consumer rights and protection. We are privileged to have someone of Mr. Gai's caliber with us today. His dedication to empowering consumers and his expertise in navigating complex issues make him uniquely qualified to help us understand how to handle health insurance claims effectively. So, without further ado, I'll ask Mr. Gai to please start his talk and start the presentation.
Good evening, everyone. Good evening. I thank Moneylife Foundation for arranging today's talk to create awareness. I will be dividing my talk into 3 parts. The first part will be how you can prevent your claims from being rejected, what you need to do. That is much better than fighting for your rights later after the claim is rejected. The second part will be dealing with various case laws, which will help you understand how the law is interpreted and what are your rights as a consumer of insurance services. Finally, I will suggest ways and means which will help you tackle your case if at all you require to go to the consumer court. Litigation is the last resort because the consumer forums also are not at all speedy these days. So let us first consider, how does a contract of insurance begin? It begins with a proposal form. So you have to submit a proposal. In the proposal, there are various declarations to be given. As an aware consumer, it is our duty to see that the proposal form is filled in correctly by the insurance agent. Many times we rely on the agent who simply asks us questions, but he puts a tick mark according to his convenience. So supposing you truthfully declare to the agent that you are suffering from diabetes, instead of putting tick against yes, he will put a tick mark against no, because he knows that he will get his commission as an agent only if the policy successfully goes through. So insurance agents have their own targets, they have their own agenda, and many times what is given, the information that is given is incorrect. So see that you fill in the proposal. If it's an illiterate person, it is different than the courts have held that the insured is not bound by the proposal form if the agent has filled it in. But if you can read and write English, then it is your duty to verify whether the information given is correct or not before affixing your signature. After a proposal is signed, please make sure that you retain a copy for your records. Nowadays, it is very easy to keep a copy. All you have to do is use your mobile and take a photograph. Because many times the insurance company says you have given such and such information. You say I have not given it. So you should have proof about the information which you have actually given. It will help you establish your case in the event there is a dispute at a later point of time. Secondly, after you get the policy, please make it a point to read the terms and conditions carefully. According to the IRDA regulations, you have a free look-in period for 15 days. Make it a point to see the terms and conditions. See if the policy contains the clauses as explained to you by the agent. I will give you one classic case of a person who had come to me for consultation. His father, he had taken a critical care policy. His father suffered a heart problem. He was in ICU for 29 days. Can you imagine what will be the amount of the hospital bill? Unfortunately, he died in ICU on the 29th day. The person was fully confident he'll get the claim. When he lodged it, he gets a reply that this critical care policy helps you to plan in advance for a surgery. The person must live for 30 days, and only if he survives 30 days from the date of ailment, then he would get a claim under the Act. The claim was rejected rightly under the terms of the policy, but wrongly if it comes to considering ethical means. So you are under a false misconception that you are covered when actually you are not covered. Next, once the proposal and the insurance policy are in place, then comes the question that God forbid if you fall sick, what happens? When you have to get hospitalized, what happens? Unfortunately, today, we have many hospitals who employ, they charge you a bomb, but they employ as assistant doctors, as registrars, as housemen, doctors who are not qualified in allopathy, doctors who are BHMS, homeopaths, Ayurveds, Unani doctors. They are employed. Many of them don't understand English properly. Many of them are careless. So supposing you say hypertension since 6 weeks and he writes hypertension since 6 years. These sort of cases have come. When the claim is later lodged, you realize in hindsight that the medical history is incorrectly recorded. So somebody has to check whether the medical history is factually recorded or not. There was another case of a Jain who used to be without food and water for days together during certain Jain festivals. At other times, he used to enjoy a little drink as a social drinker. When his history was asked for, he honestly said, I drink socially. The doctor recorded alcoholic. There is a world of difference. An alcoholic is a person who cannot survive without liquor. His hands will shake, it's like a drug addiction. He cannot survive without liquor. His claim was ultimately rejected. He had cirrhosis due to cancer, not due to alcohol. But such sort of remarks which are put in the hospital papers by untrained medical professionals create a lot of problems. Later, if you try to represent that the hospital has made a mistake, the insurance company refuses to accept that, and the stand which is taken is that when you wanted treatment, you gave the correct history. Now that you are well, you are finding ways and means to just make money and get your claim, although it is not payable under the terms of the policy. After the hospitalization period is over, you lodge a claim. When you lodge a claim, please see that all the documents which are being filed in support of the claim, you keep copies of those documents. Many a times, the insurance companies, the TPAs who provide the service, lose the documents, and after that they keep on calling you and saying this document is missing, that document is missing. Make sure that all the documents are submitted. List out the various documents, make a list, and then submit the documents and take an acknowledgement. I know it is tedious, but taking that acknowledgement can prove that you had submitted the document. If you have no proof, it is your word versus the TPA's word. How are you going to prove it later? Same way, when you get the hospital bill, keep a copy of the bill. Make sure that the original bill is submitted. Sometimes there are people, it's a society, so there are people who are out to cheat the insurance company also. Let us face facts. So sometimes they claim that we have lost a bill, we are giving you a PDF copy, a soft copy. Now the insurance company cannot make payment because you can submit the same soft copy in PDF format to 3 different insurance companies if you hold 3 different policies. So make sure that you submit the original, and where you are submitting the original, please make sure that you list out original bill, original, otherwise the rest of the things you can mention, copy of say scan report, copy of ECG, copy of this, copy of that. That is fine. But when it comes to money, make sure that you mention that the original bill is being submitted. When you want to renew a policy, particularly in urban cities, life is very fast. We don't have time to do many things. We are always hard pressed for time. Transport is a problem. We feel that the insurance agent is earning commission from our policies. So it is the agent's duty to give us the service of paying the renewal premium. So most of us, what we do is, we make the renewal payment, we hand it over to the insurance agent. So long as everything goes well, there is no problem. But let us consider, the insurance agent is also a human being. He may lose your check. There may be some problem in his family. He may not go to the insurance company. No matter what the reason, if your check does not get deposited in time, can you say that I have handed over a premium check, my policy has to be renewed, he is the insurance agent? The answer is no. This matter had gone right till the Supreme Court. I have quoted the judgment. Here what had happened was that there is a specific prohibition on the agent from collecting the premium. So if he collects it, he is not acting as the insurance company's agent, he is acting as your agent. Just as you may depute a family member, you may depute your office peon, you may depute a colleague, a friend, anybody who will go. The agent is going as your agent, not as an insurance agent. So the insurance company will not accept that if the agent does not deposit the check in time with the insurance company. You may have a policy since several years. Overnight there is a break in the policy, all your pre-existing diseases get excluded, because afterwards it will not be taken as a renewed policy, it will be taken as a fresh policy. So make sure that these small things you take care of. If at all you feel it's inconvenient to go, get a demand draft made or pay online. Otherwise get a demand draft made, send it by speed post. Then you have proof that it has been dispatched, it has been delivered. But do not hand it over to the insurance agent. One of the most favorite clauses under which claims are rejected is that there is suppression of material facts in the proposal. Now, what is the meaning of material facts and when are they material? Firstly, the fact should be within the knowledge of the person. Sometimes people have some symptoms. The symptom is not diagnosed as a particular ailment. So though you have a symptom, you don't know you are suffering from the disease. Sometimes the symptoms are similar. So there is something called differential diagnosis, whether the same symptom is caused by disease A or whether the same symptom is triggered by disease B. So till the doctor arrives at a diagnosis, even you don't know that you are suffering from that disease. Now if you don't know about the existence of this disease, how can you disclose something which you did not know? So if it is to be treated as suppression, then it is the insurance company which has to discharge the onus of proof, the burden of proof, that you knew it, you have consulted so and so doctor, you are well aware this is the finding, and yet you have suppressed it. If the insurance company cannot prove that, even if there is a pre-existing ailment, non-disclosure would not result in a repudiation of the claim. You would still be entitled to get your money from the insurance company. What are these black spots coming on the screen? This is inconvenient to turn. Okay. Now sometimes what happens is that there is a particular question and you don't tick the answer, you don't reply to that question in the proposal. What are the implications? The insurance company tries to say that you have not replied to such and such question, Therefore, you have suppressed facts. You have not given a truthful answer. Fortunately, our courts have construed this very liberally in favor of the insured. If there is a question and if there is no answer, why did the insurance company issue a policy on the basis of an incomplete proposal form? If it is incomplete, the insurance company could have very well said, please fill in this information, then we'll issue it. So by accepting an incomplete form and issuing a policy implies that the question did not have any real significance, relevance or importance. So it cannot be construed that you have suppressed facts merely because you have left a question blank. Secondly, supposing there is concealment of certain facts, even then there should be a nexus between the ailment, between the claim and what is alleged to be suppressed. Today, insurance companies blindly say there is suppression and arbitrarily keep rejecting claims. But if it has to be seen, did that suppression have any bearing on the treatment? Now let us say a person may have some disease, some ailment. He meets with an accident on the road, a motor vehicle accident, and he is taken for that. Accident, anybody can meet with an accident. There is no direct nexus between the ailment which is suppressed and the accident. So the claim would still be payable. That is what our National Commission has held. You can note down the important judgments if you like. Insurance companies also keep on, renewing policies over the years. But what happens when there is a claim? Let us say you have a policy since the last 15 years and God forbid suddenly you find that you are suffering from cancer. Now cancer is something, or dialysis or kidney problem, where there will be repeated periodic claims. So the insurance company then realizes that this policy, which was once profitable, we had not paid a single rupee as claim for the last 15 years, will now become onerous. We will have to pay claims repeatedly. So the insurance companies take a stand that we will not renew the policy. The policy is on a year-to-year basis. We will not renew it, or we will exclude claims. At the time of renewal, we will put that particular disease as pre-existing. Can that be done? The answer is no. You cannot exclude ailments at the time of renewal. It would be on original terms. I'll come to a judgment on that in a later slide. Most of us also find that when we lodge a claim, the amount which is sanctioned is much, much lower than what we have claimed. Under various heads, there are deductions. Are those deductions permissible? Can the insurance company say that unless you sign the discharge voucher, we will not even pay the admitted amount? That is an unfair trade practice. It is an attempt to coerce you into giving a discharge, a blanket discharge. Once you give a discharge, you lose your right to fight for a remaining claim. So the courts have held that the insurance company is duty bound to pay whatever is sanctioned. For the remainder of the claim, for the rest of the amount, the matter can conveniently be fought out at leisure. But what is admitted has to be paid. It cannot be withheld. a claim, normally insurance companies have a term in the policy, a clause in the policy, which says claims have to be lodged within 1 week or 15 days or 30 days. If you don't lodge it, the claim is repudiated. Is this correct? The answer is no. Any claim which is lodged is bifurcated into 3 components: pre-hospitalization, hospitalization, and post-hospitalization. Are you supposed to lodge 3 different claims or 2 different claims? Because post-hospitalization, the treatment is covered for 30 or 60 days even, depending on the policy. The insurance companies try to do this because once the main claim is paid, the balance amount for post-hospitalization treatment is comparatively a nominal amount, and it makes it absolutely worthless to fight for that claim as a standalone amount. You are entitled to lodge one claim for the entire ailment, and you can file it at your convenience. The period which is given under the policy is supposed to be for expeditious settlement of the claim. We know that even if you lodge it the very next day, insurance companies never settle anything expeditiously. They take their own sweet time. So it cannot be used as a ploy to deny a claim just because you file it after 30 days or 60 days or 90 days. You can file it in a reasonable period of time. This view was taken by the Maharashtra State Commission and also by the National Commission. I have given the judgments over here. These days, I think you will also be coming across people who suffer from certain sleeping disorders, sleep apnea. They require BiPAP machines, CPAP machines, whatever. The cost of these machines is around 80,000 rupees or more even. Can the insurance company say that we will not reimburse the cost of these machines? In most cases, they try to deny paying the cost of the equipment, which is required to save the life of a person who is discharged and who is better. So, such a case went to the Delhi State Commission, and it was held that the cost of these equipments have to be reimbursed by the insurance company. The insurance company also tried to argue that what if this machine is no longer required after a point of time? The person will sell it off as a second-hand equipment. So the court said that you can take an affidavit from the person undertaking that he will inform the insurance company when the equipment is no longer required. Usually it is for the rest of a person's life. So it's unlikely that the use of the equipment would be discontinued after a certain period of time. But still, the consumer who fights gets justice. In the remaining cases, the insurance company knows it is doing something wrong, but still gets away with it. While I'm just mentioning about the attitude of the insurance company, of knowing that they are doing something wrong and still persisting in that wrong, I would like to narrate one incident. There was a divisional manager who worked 30 years for a particular public sector company. 30 years, his entire life. After 30 years, he retired and he was covered under the same company's group medical policy for its employees. Later, this gentleman had to undergo some minor surgery, and the hospital bill, maybe about 15 years back, came to 22,000 rupees. When he lodged a claim, the panel doctor of the insurance company, one panel doctor recommended payment. I was aghast to find the insurance company did not pay the claim and instead approached a second panel doctor to recommend a repudiation of the claim. Based on the second doctor's opinion, the claim was rejected. After that, we filed the case in the consumer court. Small amount of 22,000 of an ex-employee. We filed the case. On the very first day, what does the insurance company do? They don't come to defend the case. They come and say, we would like to pay the claim, will you withdraw it? Now if you know that the claim had to be paid, why do you want to settle it at this stage? Why not settle it earlier? So they know that claims are being wrongly rejected. If compensation is awarded, the amount is paid by the insurance company out of public funds. Till it pinches the officers concerned, this lethargic attitude will continue. So I think we require a whole movement of people, when they take up such cases, to request the courts to give a direction that the compensation which is awarded should be recovered from the salary of the guilty officials. I think only then will the mindset change and people will get their claims without harassment. These days particularly, there are electronically generated policies issued. So you get a 3-page policy without the terms and conditions. You just get the basic schedule, the certificate of insurance. The terms and conditions are not given. Just put a small letter on record saying terms and conditions not supplied. The insurance companies mostly have a special waste paper basket for correspondence. Nobody will bother to reply to that also. The document will also show page 1 out of 3, 2 out of 3, 3 out of 3. Even if the policy does contain a clause that certain exclusions are there, those exclusions have not been supplied to you. When they have not been supplied to you, what happens? You are ignorant, you are in the dark. The duty to disclose good faith applies both to the insured as well as to the insurance company. So just as the insurance company expects you to truthfully declare your health condition in the proposal form, same way the insurance company has a duty to disclose all the exclusions by providing you with the copy of the policy. If that is not provided, the consumer courts have very nicely held that a clause which is not communicated is not binding. Even if it is there, we are not going to look at such a clause and you have to settle the claim. So please make sure that you take advantage of the insurance company's own negligence. If they can play dirty, you are just going by the rules. Secondly, many times insurance companies come up with certain interdepartmental circulars saying that this is a direction from the IRDA. This is an interdepartmental circular. This was not incorporated in the policy, but we are bound by IRDA. we are bound by the internal guidelines. Are they really bound? Yes, the insurance company may be bound by its guidelines, but when it is not provided to you, you are not bound by those guidelines. So therefore, when the guidelines are issued but do not form a part of the policy, they cannot be enforced against you, they cannot be used against you to your detriment. This matter has been settled by the Supreme Court, so there is no chance of any consumer forum or any other court taking a different view. Full and final discharge I mentioned. When there are delays in settlement of the claim, the protection of policyholders' interest regulations provide that interest has to be given. What is this rate of interest? The rate of interest is 2% over and above the bank rate which is given at the beginning of the financial year. So if the bank interest rate is 7%, for delayed claims you are entitled to 9% interest automatically. But because we don't enforce our rights, insurance companies keep delaying claims but avoid paying the interest. That interest goes into the pocket of the insurance company, which should rightly have come to you. Pre-existing, by now everybody knows, after a certain number of claim-free years, even pre-existing diseases get covered. So, the question is, you have to disclose it. There may be a slight loading in premium, but policies are issued, and after 4 years, you would be entitled to get claims even for all your pre-existing ailments. Insurance companies have argued that we will not renew a policy. It is a year-to-year contract, and it is a person's or entity's right whether to enter into a contract or not, the freedom to contract. This year I wanted to enter into a contract with you. Next year I don't want to enter into a contract with you. It is my choice as the insurance company. They have tried arguing that. The matter went right till the Supreme Court. It was a up and down case in the Calcutta High Court, finally went to the Supreme Court, and the Supreme Court has said that it would be against public policy, it would be a gross injustice if renewal is denied arbitrarily. When can renewal be denied? If the insured has tried to play the fraud on the insurance company. In other cases, the insurance company is duty bound, there is a clause for renewal, it is duty bound to renew the policy, and on what terms and conditions. Can the terms be changed? We find insurance companies keep changing the terms, but the Supreme Court has very, very categorically said that a renewal of a policy is an extension of that policy for a further period of time on identical terms and conditions. So, not a single term can be changed except with your permission as the insured. Let me put it the other way around. If it is considered that the insurance company has a right to change the terms, tomorrow if you put in a new term, will the insurance company accept it? The answer is no. Then if the insurance company puts in a new term, why should we accept it? No. So the Supreme Court has made it clear that the policy has to be renewed. it is not on a year-to-year basis so long as you pay the premium in time. The focus is renew by paying premium in time. If you renew it in time, the very first policy which was issued, at the time when you filled in the proposal form, it has to be renewed on the same terms and conditions. If there are going to be any changes, then those changes have to be communicated and your consent obtained. Just communication of the changed terms is not sufficient, but your acceptance is also required. If you don't agree, then it cannot be unilaterally changed as per the whims and fancies of the insurance company. Genetic disorders, sometimes they are there since birth. It's in the genes. But they don't manifest themselves till maybe several decades later. There are cases when the person comes to know of a genetic defect even after 50 and 60 years. Can you refuse to pay the claim regarding genetic defects? The Delhi High Court held that it is not permissible to deprive and deny a person of the claim when he was not aware of the genetic defect. All genetic defects, whether mentioned or not, exclusion would be opposed to public policy, and so it would be unenforceable. After that, the IRDA issued a circular saying that all genetic claims have to be paid. Meanwhile, the insurance company has approached the Supreme Court. So IRDA came out with a second circular saying that our first circular will not be implemented. So currently the Supreme Court is seized of the matter. Will that change the scenario? So I'll explain the legal position to you. Till a judgment is given which is contrary to the first judgment, the judgment still stands. Supreme Court has not set aside the Delhi High Court's judgment. So the judgment which is given by the Delhi High Court holds the field today. It is still binding. If at a later point of time, as and when the Supreme Court decides the matter, it sets aside the judgment, then it is a different thing. Supposing a similar issue goes before another High Court, then in that particular state, the interpretation given by that High Court would prevail. Today, there is no contrary judgment by the Bombay High Court. So the same Delhi High Court judgment is binding on the consumer forums throughout Maharashtra. When there are, let us say, I am giving you a hypothetical example. Supposing two different courts, that has not happened, but supposing two different courts take conflicting views. Let us say Gujarat High Court takes one view, Bombay High Court takes another view. In Maharashtra, Bombay High Court's decision would be binding. In Gujarat, Gujarat High Court's decision would be binding. And in the remaining states throughout the country, the courts would be free to decide which judgment to accept. So it would depend on the judge whether to accept the Gujarat interpretation or the Bombay High Court interpretation. But as of now, there is one single judgment on genetic disorders. So it holds the field today and it is binding. After a claim is processed, a person who is not satisfied with the claim has a right to approach the insurance ombudsman. The first thing that I'd like to tell you, it is a speedy remedy on paper. What happens is, my observation of the functioning of the insurance ombudsman, I am extremely sorry to say, the insurance ombudsman is a retired CMD of a public sector company. So he is hell-bent on trying to protect and defend the insurance company. Luckily, supposing you have an LIC person from an LIC background, life insurance background as the ombudsman, he may go against a general insurance. But a general insurance person may go against life insurance. But a general insurance ombudsman coming from that background, that culture which we are fighting is more deeply embedded in his blood, and he does his best to try and protect the insurance company. I'll just narrate this because you will be amused to hear these two incidents. There was one case where the Association of General Practitioners had taken a group mediclaim policy to cover its employees. And being a doctors' association, they were authorized to scrutinize and process the claims instead of referring it to a third party or another panel doctor. 4 doctors, unconnected, they lodged individual claims during a particular period. It so happened that the meeting of the association had just taken place and there was a delay in processing the claim. Because the claim was not processed, the insurance company rejected the claims of all the 4 doctors. Now, of the 4 doctors, 3 went to the ombudsman with 1 person. 1 of the doctors came to me. Identical facts, identical thing, no difference. All had lodged claims. Association had not processed it within 30 days and the claims were rejected on that ground. The 3 doctors who approached the ombudsman, insurance ombudsman, dismissed their complaints. The 4th doctor whom I represented, I found the insurance ombudsman extremely antagonistic towards me. He was extremely rude, egoistic, and when I cited certain consumer forum judgments, he said, "Why are you showing me judgments? Do you think I can't think on my own?" We can cite judgments in the Supreme Court. The insurance ombudsman is not the final authority. His decisions can be challenged in the consumer forum. So why should he refuse? I said, it's my duty, I am giving it to you. Whether you consider them or not is your headache. I am filing them. You do what you like. And I just walked out. Very surprisingly, this one doctor whom I am represented got a judgment, a wishy-washy judgment, saying that it is true that claims should be considered on merits, but how long should the insurance company wait? So I am sanctioning 50% of the claim. Now, when 50% of the claim was sanctioned, those 3 doctors who had not got a single paycheck got agitated. They came to know through the association. They came to me. This 4th doctor, I told him, let us file your case along with them in the consumer court. And he said, Nara Baba, I don't want a headache. Aadha milta hai, le lo. So he took his 50% amount. His case got closed. The other 3 doctors, when we argued the case in the consumer court, we got the full amount plus compensation plus interest. So you can understand how arbitrary the ombudsman is. Second case, there was a lady who underwent surgery in Breach Candy Hospital. No matter what anyone may say, Breach Candy Hospital at least does not have a bad reputation about manipulation of bills. You cannot get fake bills from Breach Candy. Breach Candy issued a bill for the surgeries, something like 33,000 was the cost. There were 2 surgeries in the armpit, 1 in the groin. The insurance company said, we consider it reasonable, 10,000 rupees as reasonable, reasonability clause. The matter went finally to the Ombudsman. So I said, we have saved the insurance company considerable money suffering at 3 locations simultaneously. If we had gone for 3 surgeries, there would be 3 operation theatre charges, 3 times for anesthesia, 3 times for surgery fees. It would have been much more costlier. Here they admit 10,000 at 3 locations. Our great Ombudsman passes the order. I agree. Insurance company has considered 10,000 per site reasonable. 10,000 into 3, I am sanctioning 30,000. Rejected 3,000 rupees out of 33. So you can understand the mentality of the Ombudsman. So it's your luck, no harm, you can try. If you are lucky, you'll get it. At one point of time, there was a retired judicial officer who used to pass good orders. So it depends on your luck. It's a lottery. Who's deciding your case at that time? You may get a favorable order, but most likely not. Now, when you approach the Ombudsman, after that, if you want to go to the consumer court, what is the limitation period? Because limitation is considered 2 years from the date of rejection of the claim. Now, what do you mean by rejection? Is it the first rejection when the divisional office rejects it? Is it the second rejection when the redressal cell or a grievance cell of the insurance company rejects it? You approach the CMD, the regional office or a head office. There may be a third rejection letter. After that, you approach the Ombudsman and the case lingers there and he rejects your claim. So, 4th rejection. So, which date is to be considered for a purpose of computing the limitation period? Insurance companies had tried to argue that it is 2 years from the date of the first repudiation. We had to point out to the consumer courts that if this interpretation is adopted, you will be forcing everybody to avoid approaching the Ombudsman because the claim would get time barred in the consumer court. So the limitation has to start from the date when the Ombudsman rejects the claim and not the insurance company. Fortunately, the Maharashtra State Commission upheld that view, and now you have time to approach the Ombudsman and then the consumer forum. So much about health insurance. Now I'll come to certain aspects of the Consumer Protection Act and then we'll have the question and answer session. So the Consumer Protection Act of 1986, which was extremely good, was unfortunately amended in 2019 and the result is quite chaotic, unfortunately. I'll be very candid with you that today, avoid the consumer forum if you can avoid it. Only if there is no other recourse and you feel you can wait patiently for justice, then approach the consumer court. I'll tell you why. Originally, when the act was passed in 86, that time the jurisdiction of the consumer forum was based on the quantum of the amount or the relief which you are claiming. So if you are claiming X amount, it would 20 lakhs district forum, maybe 1 crore state commission and over 1 crore national commission, because it is on the basis of the value of the relief claim. Now today that whole concept has been changed, which is nowhere here even in civil litigation. And what is done is jurisdiction is based on the value of the consideration paid. So if I pay 5 lakhs as consideration, I can claim 100 crores at the district level, because it is not on the basis of what I am claiming but what I have paid. So insurance claims, let us say, big corporates also, how much is the premium? The jurisdiction of the district forum is 50 lakhs consideration. How many policies have a premium which exceed 50 lakhs? How many medical bills are there which exceed 50 lakhs? So you can pay up to 50 lakhs consideration, and the sky is the limit. You can claim 5 crores, 10 crores, 100 crores, whatever you want, and all that gets cluttered at the district level, unfortunately. State commission is over 50 lakhs up to 10 crore. National commission is above 10 lakhs, 10 crores. So it takes a lot of time for cases to be decided. Unfortunately, during the COVID lockdown, all the experienced presiding officers and members retired. Today, those who are sitting in the chair presiding over the consumer forums have been put there due to, you can understand what I am trying to say, and because of that, the Bombay High Court, the matter was challenged in the Bombay High Court. The Bombay High Court passed an order saying that all the appointments are illegal. All the appointments are illegal. And after that, the government has gone to the Supreme Court and the matter is stayed, and on the basis of the stay, all those members who were declared to be illegal are still presiding over the consumer forums. Territorial jurisdiction, there has been a good change in that. Earlier you had to file a case in a consumer forum where the opposite party decided. So your place of residence had no bearing on the dispute. Now after the amendment to the Act, you can file a case where the opposite party resides, carries on business, where it has a branch office, where a cause of action arises, and also the addition is that you can file it where you reside or work, carry on business. So that has made it easier and closer. Justice has been brought to the doorstep of the consumer. But even earlier, nobody would buy something from some remote place. They would normally buy it at the most convenient place. So that has not had a major impact as far as consumer litigation is concerned. The best part is, let me repeat, the best part about the new Act is, you know, earlier you have those advertisements, motorcycle, 70 kilometers per liter, fill it, forget it. You remember those old advertisements? Same thing for consumer forum. It can be file it, forget it. You file the case, they cannot dismiss a complaint which they used to do earlier if the complainant remains absent. Earlier what the consumer forums used to do, 10 days you are there, taking leave from your work, going there, following up the matter, and nothing would happen. One day you just get late. Complainant absent, dismissed for non-prosecution. They used to dismiss it. That way they used to try and show that there was a disposal. Now in the new act, they cannot dismiss a complaint. They are duty bound to decide it on merits, whether you are present or you are absent. Thank you. If you have any questions, I'll answer those.
My name is Hariram Chaudhary. I have 2 points. Supposing a person is taking the medical policy from the age of 50 years and he lives up to 90 years, whether the insurance company is bound to renew every year or they can refuse it because of the age. So
No, they cannot refuse to renew.
Even if 90 years already, they live up to 90 years. Very good. Secondly, whether the right to information act is applicable to the insurance company.
Sorry, the right to?
RTI Act, right to information act.
It would be applicable to the public sector companies, not to the private sector companies. But in certain cases, the Central Information Commission has interpreted that if a public authority has a right to access that information, then you would have to approach that public authority with a request that this information should be obtained and furnished to you. No, I asked him. I saw his hand, so I asked him. Huh.
Good evening, my name is Vian Kulkarni. I have a simple question. Nowadays, policies are being issued as cashless facilities available. But some of the hospitals have put a board that cashless facility is not available and your policy is not available.
Excellent question. Excellent question. And it will stir up a hornet's nest. I'd love to answer this question. Okay. Anyone from here who can tell me this cashless, who is giving this cashless policy? Can anybody answer? Cashless is being provided by who? Sorry? No. That is the problem. The cashless facility, you walk into the hospital. The TPA maybe gives an approval letter, what they call an AL. It issues an approval letter. You are taking treatment, all the treatment costs, doctor's fees, equipment, everything, that component is being provided by the hospital or the doctor, not by the insurance company, not by the TPA. What happens is, after you get discharged, the insurance, the TPAs particularly, it's a matter of disgrace. You may be just one patient with a claim of maybe 1 lakh, 2 lakh, but imagine a hospital where there are thousands of patients, or at least hundreds of patients, each with a bill of, say, on an average, say, 2 to 3 lakh rupees. To what extent is the hospital giving cashless facility? Now, what the TPAs do is, they deliberately, just as an individual lodges a claim, they delay. You are well aware, I don't think I have to elaborate that, everybody has had that experience. They will delay the claim of the hospital. They will not sanction it. How does the hospital survive? Then they will say, okay, if you give us 20% kickback, we will sanction your claim. So, to recover the money, the hospital has to give a kickback to the TPA. And then the amount is disbursed. Because of that, what happens? Doctors and hospitals are getting a bad reputation. You will find one rate of charges for those who have no Mediclaim, and a second schedule of charges for those who have Mediclaim policy. Why? Because they have to add and recover that 20% which they are paying under the table to the TPA. It is the insurance company which pays the money to the TPA for disbursement of the claim. It is public funds. This question was put at a medico-legal conference where a very senior official from the IRDA was invited. And he very nonchalantly says, it is a matter of demand and supply economics. You want your money fast, you pay something. Very simply, very casually he answered this question. And then when he was told, is this legal? And can public funds be frittered away like that? Because who is paying that 20%? That is not part of the treatment cost. But it is the insurance company who is paying that because of an inflated claim. Then he sheepishly said, okay, we'll look into it. So that answers your question about the cashless.
Yeah, my question, suppose I fall sick after, or say when I'm on a trek, or say I'm doing this Mumbai marathon and I get some injury, or maybe something just around that time. Will the insurance company say this was some adventure activity which is not covered under the policy and reject the claims?
They do try that. Believe me, if at all they can find something to cling to, they will always try to cling at the straw and reject your claim. In fact, currently there is one case which is being argued. A person had gone to Phuket on a pleasure trip and he was using that jet ski. The jet ski was being driven by a trained person and it met with an accident. He had to be flown by air ambulance to Mumbai and underwent several surgeries, maxillofacial surgeries, and the claim was lodged for that. The insurance company termed it under a policy as a risky avocation, saying that risky avocations are excluded. Now the first thing is, there is a risk in anything. Even if you cross a road, there is an inherent risk. Here the ski is being driven by a trained person. So you can't say, it is not as if a novice is doing it. You may be in a speedboat, you may be anywhere. A trained person is operating it. Secondly, what is the meaning of avocation? Vocation is your main source of livelihood. Avocation means that you are turning a hobby into a sort of livelihood. So let's say you are working in the insurance company. In the evening, photography is your hobby, so you work as a photographer after office hours. So photography would be your avocation. Here it is not an avocation because he was not earning anything, he was paying for it. And he had gone on a pleasure trip. The case is currently going on. So they do try, if you fight it, you will get your claim. Remember, it is a cat and mouse game here. Out of say 1000 claims which are wrongly rejected and they know they are wrongly rejected, 200 will go maybe to the grievance cell, maybe 100 will give a legal notice, and ultimately 50 will file a case. Those 50 who filed the case settle the claim, remaining 950 का तो पैसा बच गया ना. So that is the thing, they will reject it, but you fight for it, you'll get it.
I also filed one claim today for a family member, so in that regard I want to ask, many times these guys want the originals of MRIs and all the echocardiograms and you cannot Xerox them, these are medical plates.
You can, you have to
tell. Needs them for follow.
Agreed, totally agreed. First of all, there is no provision in the policy requiring you to submit the originals. If they are reimbursing the claim, it is originally the bills which have to be submitted. What you could do is, you could take them Tell them that I am prepared to show it to you. These are required. If you can, you take photocopies. There are certain sophisticated machines where you can scan those documents also. But you can simply say, I am not going to part with these. These are required for follow-up treatment.
Yeah, my name is Mohammed Afzal. The basic reason why people take Mediclaim policy at the younger age is so that they can be covered at the old age. Currently, I have seen a pattern where the insurance company, like you have the robotic surgery, you have some latest techniques which have been introduced, and all these things are not being addressed by the insurance company. They go in for a certain packages. Now it is very, very important to update these packages to include the latest techniques and the latest surgeries, which is not happening, and because of that, not many people have been asked to pay maybe 2 lakh rupees, maybe 3 lakh rupees, and they are not accepting it. What is your take on this particular thing?
See, again the same thing that I have always been saying. Unless the consumer forums really become vigilant and they pinch the officers concerned by ordering the compensation to be recovered from the salary of the guilty officials, the situation is not going to improve. Robotic surgeries are covered, they are being paid, but again provided you fight for your right.
Sir, in my policy, there last year there
As I again told you, they cannot change the terms of the policy. It will be illegal. So they still have to pay. Please make it a point to keep your original policy. Policy period khatam ho gaya, fire dala, then gone. The court will require the original policy and the current policy, and then you can point out that this clause was not there in the original. It cannot be incorporated in the renewed policy. So please make sure that you keep your original policy, at least the first one with you.
Good evening, sir. I'm Tushar Joshi. Of late, insurance companies are reducing the claim on the reasonability clause. So how to fight for that?
That is again totally unjust, illegal. We have won several cases. What is reasonable? Reasonability clause, you can go to a municipal hospital or a government hospital and get the same surgery done for a few thousand rupees. Why do you go for a Mediclaim? There is no need. You go for a Mediclaim policy because you want a certain standard, a certain level of health care. Now when you go for a policy, you are putting your health and your family's well-being, because you may be the sole bread earner in the family. You won't go to any doctor just because he charges you the least price. You will not say, okay, kaun sa doctor sasta hai, I'll go to him. You will go to a doctor in whom you have faith. You will go to a hospital where the cleanliness level is up to your expectation. The doctor's fees will be commensurate with his skill, his seniority in the profession, his reputation. Perhaps a hospital which has been set up 50 years ago, the rental cost is nominal. Today a person who sets up a hospital has to pay a bomb for a land cost and for the infrastructure cost. So costs differ. It may be in the same locality, but something that was set up, a building constructed 50 years ago, let us say like Bombay Hospital, their land cost and rental cost will be a fraction of what the property was cost today if I were to buy a plot adjacent to it. So my charges and another person's charges would differ from hospital to hospital infrastructure to infrastructure, seniority of the doctor, and not only that, the condition of health of the individual patient. I may just have a simple cataract. XYZ may have diabetic retinopathy. So the cost of treatment would definitely be more because the doctor would have to put in extra effort. Do you as a consumer have a right to tell the doctor that I will not pay these charges? The insurance contract says it will indemnify you the cost of health care, the hospital cost, the treatment cost. If you have legitimately incurred it, the insurance company cannot disallow that. I have got cases where even trifocal lens costing about 2,50,000 has been paid for under a cataract claim. Only thing is you require grit and tenacity to fight for your rights.
Good evening, sir. My name is Ombudsman. Sir, it happens in some cases where I have taken a policy where I had no health issues. 2 years down the line, I am diagnosed with diabetes. 5th year, I apply for a claim for some reason, and it goes in the case paper that I am diagnosed with diabetes. But sometimes it happens I am not able to provide the consultation paper when I am diagnosed with diabetes. In this case, the company rejects the claim saying that you had not given the information correctly.
Okay, the law is very clear. Can you prove something that is negative? You can't prove that. Who is making the allegation that you are a diabetic and you have suppressed it? The insurance company. So the burden of proof is on the insurance company. They have to contact maybe your family doctor anywhere and show that Mr. So and so has first consulted this doctor, this is the treatment given, produce the document, and then say that you have concealed that fact. If they cannot show that, you are entitled to your claim on the basis of wild allegations, surmises, conjectures. The claim cannot be rejected.
My name is Vivesha. My question is that whenever we go to the big hospitals, they have GIPSA compliances. Then also they are clearly, Ms. TPA said you don't have to take from him some amount, whatever amount may be there. Then also they are this big hospital saying if you can't give, who can give the? आपका बाप नहीं रखा है, सभी wording is using that. How do we fight the hospital? How do we fight the insurance company?
See, you have to pay the hospital what is rejected and then fight it out with the insurance company. Because the hospital is providing, if you are going and taking their services, let's say you go for a cup of tea down below and you go for a cup of tea in Taj Mahal or even Ambassador or Gaylord, there will be a difference in the price. So you would have to pay that amount. It is the part of the hospital tariff. You pay it and you fight it out with the insurance company.
But then also they are saying that it is our GIPSA is there, why you are paid? Insurance is selling that way.
See, when the hospital bills, again the same thing, fair and reasonability clause. Under reasonability clause, can you tell the hospital I am not going to pay this amount? Maybe tomorrow when you fall sick, you will have to go to the same doctor in the same hospital. So you cannot tell the doctor I am not going to pay it.
Question is connected to this only. It is basically agreed rate where we have give you the market.
Are you a party to the agreed rate? The answer is no. Is it a tripartite agreement? The answer is no. The insurance policy is not a tripartite agreement. The insurance company may have one contract with the hospital. Let them pay you, let the insurance company, as in commercial policies, you have subrogation. So what happens? They pay the claim and on the strength of a letter of subrogation, the amount is recovered. Same way, Let the insurance company take a letter of subrogation from you, tell them, recover it from the hospital if it is wrongly charged.
So here we mean to say is that the TPA and the hospital has entered into an agreement of cashless, where the rates and everything are decided and agreed by both the parties.
Are you a party to that?
No.
So if you are not a party, it is not binding on you. Simple.
Okay. So that was the main concern.
Correct.
She was asking.
You are not a party to that.
Yeah, I got it. Legally I understood that. Thank you.
हेलो
हेलो, इस प्रशांत डिग्री अभी जो आईआईडी का नया रूल पास हुआ है प्री एग्जिस्टिंग डिजीज पे, जो अभी समझो 4 साल या 5 साल पॉलिसी पूरा हो गया तो ऑटोमेटिकली एवरीथिंग इज कवर्ड।
Yes, everything is covered.
तो व्हाट इज दैट पीरियड?
48 months.
48 months.
48 months.
तो अभी डिस्क्लोज नहीं किया समझो।
Disclose, if you have not disclosed it, the insurance company could have the right to say suppression of material fact. So they can even cancel the policy if you have suppressed fact. If you have disclosed it, for 4 years it would not be payable, from the 5th year onwards it would be payable.
Sir, you talked about cataract surgery. Now, even though there was a sufficient policy amount, the insurance company capped that operation cost.
Mic a little.
Operation cost was capped, even though sufficient policy amount was available. So,
Capping is permissible so long as it was there in the first policy. If it was not there in the first policy, subsequent capping is illegal.
no, it was first policy only.
No, then it is permissible.
So, in this case, it was not allowed, and I am wearing stacks.
Correct, because capping was put in the very first policy.
But is it justified?
It is a contract, so freedom of contract. If you want, you take it. If you don't want, you don't take it. Or go to some other insurer. So you cannot do anything about that.
Even the sufficient policy amount?
Yes, because for a particular disease it was capped, for a particular ailment. Same way as there is a capping for room charges, other things. So capping is permissible, but provided it was there in the first policy. Supposing the original policy did not have that capping, renewal, you cannot have capping at the time of renewal.
The original was capped.
No, then you can't do anything.
Hello, my question was, right now we have filed a case with Ombudsman, and right now Ombudsman do not have a judge because the current judge has retired and now they don't have a judge. So can we simultaneously file the same case with Consumer Court?
You can file it, make an application to the Ombudsman that we want to withdraw it. We are approaching the Consumer Forum.
Oh, we can go to
Just send a letter
okay, we have to send a letter to Ombudsman.
to the Ombudsman and approach the Consumer Forum.
Okay, thank you.
Hello, my question is about this condition. It's rejected based on the non-disclosure or concealment of material fact. In practice, how exactly does it operate? Because I will give you an example. Currently, I am fighting a claim on behalf of my friend who had a hypertension, but whatever reason he did not disclose it. In the 4th year, he had a heart attack. Of course, I didn't know about the case laws and all. But at that time, before the national insurance, I did argue that the fact has to have some nexus with the heart attack. And in the instant case, since he was operated in the Jaslok hospital, the treating surgeon had given a certificate of the Jaslok letterhead. He is the renowned cardiac surgeon, saying that this hypertension has got nothing to do with it. But still, the claim is rejected. Right now, it is lying before the Ombudsman. But the insurance company took the stand, it is simply a suppression of the material fact. So
that is what I agree with that is what they do, but it is not correct. I'll put it this way. Does every single person who suffers from blood pressure, who has high blood pressure, does he get a heart problem? No. Does every person with a heart problem have high blood pressure? The answer is no. There could be an incidence maybe, but there is no conclusive evidence that it is 100% due to high blood pressure. In fact, there are some judgments which say that in a busy life, almost everybody suffers from high blood pressure. People are always under stress here. So it is no longer considered something which is very serious, and it can be controlled medically. Sorry.
Regarding this moratorium period, has it this period of 8 years has to be with one insurance company, or if there is porting between two insurance companies?
No, I did not follow your question.
Mediclaim health insurances carry a moratorium period. After 8 years, it is not contestable, any pre-existing disease.
It goes simply by the policy.
Yeah,
I have not come across that. But at the time of porting, the other insurance company makes an inquiry with your previous existing insurer.
No, this is regarding the moratorium period.
Now, what exactly is the clause? You have to show it to me.
In that, they say that for 8 years, if you are continuously covered for 8 years, then anything is covered.
As I have told you, it's 48 months, 4 years. I have not come across this. We'll have to see the.
He means to say when he's quoting the policy, the moratorium period will also be quoted along with it in the new company. Right?
Yes, it would be. It would be, but not 8 years. It would be 4 years.
Moratorium is a different thing. It's not pre-existing. Moratorium meaning company cannot reject your claim based on that anything due to any reason. That is after 8 years.
We would have to see the exact clause, how it is worded. There are people who have lodged claims after 15 years and they come up with pre-existing also. So what exactly is the wording? Is it incorporated in any policy? So I'd have to see it, because in the Mediclaim policy, it's a standard policy. Are they incorporated in the policy? Do you have a copy?
Section 45, which is in insurance, life insurance.
That is life insurance. We are on health insurance here.
In health insurance, after 8 years, that moratorium period is valid. So you cannot reject, company cannot reject based on under any ground.
But if there is a clause, under which particular section? So we would have to see the section, because I have not come across that section so far. So we would have to see it. If that is the law, then that is the law. It cannot be rejected.
So this is as per health regulation, whatever is by the IRDA.
So that would have.
Earlier it was 8 years, now it is 5 years.
So that would have to be cited then. If it is there as per the regulations, they can't do it. Very clear.
Now it's 5 years. But there is some
We would have to see exactly what are the exceptions, what is what.
Something like that. His contention was that whether that moratorium period credit will be given when he's quoting the policy.
That would have to be seen in the light. I cannot comment without seeing the particular section.
Sir, would you make this Madheva?
Sorry?
This is a tragic case where there is deficiency on the part of the insurance company on several counts. I am just using a matter of just 2 minutes. The patient was admitted for a particular disease. The influenza was there for a few months back.
You are not clear.
The patient was admitted in the hospital for influenza. Now the patient was already suffering from heart disease. Corona, post-corona, the problem was there. At the time of making the proposal, it was made very clear to whoever was the person who was preparing the proposal. Corona was there. After corona, heart disease was there. Everything was. But the person who has made the proposal, he has used one particular term that is not a part of the disease at all. That is not a part of the disease. Sir, I just come in.
Please don't ask me such questions, because the proposal is not before, please keep it to general questions.
Now, the second is, when the person was admitted to the hospital, the person was not, cashless claim was there. When the cashless claim was, then they said, no, the person is suffering from cancer. It was made very categorical, the person is not suffering from cancer. Still they said, not twice.
So then that is against the hospital if they are giving a wrong diagnosis.
It is not the hospital, it is from the insurance company.
From where did they get that? Then you can challenge it, saying that it is an imaginary ground of rejection.
Yes, sir, it is imaginary ground. And after giving all the proposals, all the bills and everything, we have made an appeal to the CEO of the company. And CEO of the company, there is no reply from the CEO of the company. But from our side, we have argued, since I have...
Which is the insurance company? Is it a public sector?
Renewal, sir. So we have said, I have quoted from ex-insurance company SDFC Ergo to Diva Bupa. Therefore, Diva Bupa is supposed to have all the details of my earlier SDFC Ergo also. Because since I was...
Whoever has given, if it's, there's no point in discussing this point further. The insurance company would have to show that the diagnosis of cancer, they would have to substantiate it. If they can substantiate it, they are right. If they can't substantiate it, you are entitled to claim, you can fight it out.
So, but the question is, when I have quoted from one insurance company to another insurance company...
I'm repeating, please don't repeatedly ask me specific questions when the documents are not before.
Good evening, sir. It's regarding the robotic, these two gentlemen earlier had said. I was operated for prostate cancer in November 23 at a reputed hospital, covered by a very reputed private agency. And they paid me only 50%. So can I claim that 50% still now?
If you have not given a discharge voucher, saying you have received it in full and final satisfaction, and if you are within 2 years of the date from when the claim was paid, you can still file a case.
Okay. Second question is the new government schemes floating around, Ayushman, all those are also covered on the list if there is a dispute, because I work in the social sector where I have a lot of underprivileged people.
I don't follow how. See, if you are entitled, if it's a free scheme,
no, you pay something.
You pay.
So, 2 lakhs.
So then your claim would be restricted to that amount.
Yeah, that amount. But if it
so long as you have spent on medical treatment, where you have spent it, whether under Ayush, whether a private hospital, whether in a nursing home, will not make any difference. You will be entitled to reimbursement.
Thank you.
2 questions. One is the premiums of all insurance companies are hiking their premiums like anything. They are all going over the roof. Can we do something about that also?
Not likely. Unless somebody files, some depends on the judge also, because the cost of living is going up overall. 5 years ago, what was the cost of an LPG cylinder? What was the cost of tomatoes? So it depends. Whether it's absurd, it depends. I don't think anything can be really done about that.
People stop their income plus
I agree with you. I totally agree with you, but what I'm saying is that I don't see any remedy which is available for that.
The second question is, does this consumer forum verdicts apply in general or it is specific to that particular case?
The law point applies generally. The facts apply to a particular case. So the interpretation of law would apply to all the consumer forums.
But then to get that judgment, everybody has to approach them on their own separately.
Or you have to maybe just look it up on the net and try and get that judgment. You have to do a little research.
But then will the companies comply with that?
No. These judgments are in public domain.
Okay.
So you can get them. The insurance company won't furnish you with a judgment against it.
The companies comply with that because as you said,
They do comply.
They do comply.
I am covered by Ayushman policy, being above 70 years of age. Free treatment for up to 5 lakhs. The open heart surgery, the bill comes in the same approved hospital for 7 lakhs, and I have a medical policy of 2 lakhs rupees, but the insurance companies are different. So what will be the position?
No, I have not followed your question.
See, Ayushman policy up to 5 lakhs rupees, I will be covered under Ayushman policy.
Correct.
I am in the same hospital which is covered by the Ayushman government. But the open heart surgery bill comes to 7 lakhs.
Okay, I'll explain.
And 2 lakhs in my...
I'll explain. Supposing, let us say you have a policy of 3 lakhs with Oriental, 3 lakhs with New India, and your claim exceeds, say, 3 lakhs or exceeds 6 lakhs. Then proportionately whatever is payable on a pro rata basis the insurance companies would share it. Same thing.
Mr. Gai, I have always been reading your articles in the papers and I was always delighted. But today is the first time I hear from the horse's mouth. It has been a sheer delight.
Thank you very much.
I purposely came here because there have been very crying situations that I have come across. The first thing that I want to ask you is, normally when a claim is denied, they say that you have to approach the insurance company. Ombudsman does not accept it unless you
go one step further and lodge a claim with the complaint to the
normally I've seen, because in 35 years I have seen how it works. Because you put in an application, the application is sent to the TPA and they say we agree with the findings of the TPA. So basically it is not an independent assessment of the thing, right? I brought it.
In fact, now under the new rules, the TPA is not supposed to inform you that the claim is rejected, it is the insurance company. But no matter what, maybe the position, you have to comply with that approaching one authority higher than the claim rejection. So you do that, if whether they respond or not is immaterial, after 30 days you are entitled to approach the Ombudsman.
Regarding one gentleman who had asked now, whether a verdict, is it binding on the insurance company as a one-off situation or in general?
In that particular case, it is binding on the insurance company to comply with the order. It is binding on the insurance company to comply with the order and make payment as directed. So if it says that pay Mr. X, and so X is the complainant, then they have to pay X. Why would have to fight for his rights independently? He can cite the judgment of X and say that my facts are identical. But it does not automatically become applicable to Y, because the court would have to see whether the facts are really identical or not.
Okay. But in practice, it is not taken that way. They say it is not a precedent that we have to follow the judgment.
See, the law is a precedent. Facts cannot be precedents. So the law, there is a precedent. Let's say if the law says that this reasonability clause, the interpretation, that would be applicable to you, me, X, Y, Z, everybody sitting here.
Okay. So the third and the last one is the modern treatment that is...
That I think somebody asked, robotics.
Yeah. Now, I'll just, because this is an issue that I'm facing. See, this person had a 10 lakh of insurance, and at that time, this capping was not there. In fact, it was not introduced. That concept of modding, it came just about 2 years ago, I think. But this man already had cancer, and his 10 lakhs was exhausted. Subsequently, in the next year, when it was renewed, they found that he had galloping cancer, it went on to his liver, and then they said the traditional mode of treatment is not going to work, we have to give the targeted therapy. One injection cost is costing 2,10,000, and he had to have a series of 10 injections. And what the insurance company did, they paid only 2 lakhs, and after that they said, no more, you have exhausted the limit. Now my question is,
what was the sum insured under the policy?
10 lakhs.
So they would have to pay a series of claims till it comes to 10 lakhs.
No. In this, there is a capping. There is a capping up to 2
You
lakhs.
said originally there was no capping.
There was no capping.
So it would not be applicable.
No, but then earlier, modern treatment was not covered.
It makes no difference. That would not make any difference. Science and technology keeps on changing day by day. What may be considered the right methodology would be found redundant tomorrow.
Yeah.
So forget that methodology. Even the concepts keep on changing. Equipments keep on changing. So that would not make any difference.
So what they did, sir, is they said they went by the wording of the policy clause and they said that is it. Now what has happened is there is a clause. If at renewal you want to incorporate that thing, existing cancer patient cannot take this particular thing. So he's stuck. He's just stuck. So I was just
he will have to go saying that this particular clause was not there. Okay, tell me, when you took the policy first, did you have laparoscopic surgery, keyhole method of surgery? No. You had open surgeries. So technologies and science and technology keeps on changing, but that does not mean the ailment was not there. The treatment for the ailment is covered.
But can they put a cap on it?
Not if it's not there in the original policy. So there is no question of putting a cap.
So there are policies which have cap on.
So that is illegal. That is why I say keep the first policy, compare it. It's not there.
Good evening, sir. I am Jagat Gandhi. I have been reading your articles in Times of India, and really it was very educative. Right now, whatever information you have advice you have given, I really am thankful to you.
Thank you.
Sir, I have one question regarding the time of limitation. You said 2 years after the Ombudsman verdict. Now, the Ombudsman in my mother's case have given a verdict in 2016. But during that time, the Ombudsman had not seen the policy document, nor I had seen. And this was a group insurance policy which I had taken for my mother in 2015. I am talking about 2015. Right from 2010 to 15, I have been taking the same policy. Now, in that, it was written 20% co-op. So whatever the insurance, whatever was granted by the TPA,
20% you have to pay.
Yeah, I have to pay. So that was, she was admitted to the hospital, cashless was done, everything was fine, but the problem was pre and post treatment. Now my mother was on the bed and the doctors have given the certificate that she needs nursing care throughout. So the nursing care they did not allow, the TPA did not allow, and also the ambulance charges also, they allowed from home to hospital and hospital to home, they did not allow. Now when I asked them, in front of the Ombudsman, there was a hearing prior to the Ombudsman passing the order. During that time, the Ombudsman asked them, where is the policy? Show me that the to and fro prior, only to the hospital it is allowed, and from hospital to home is not allowed, even though she was on catheter, even though she had bad sores, she could not be transported except with, by an ambulance. So it's a lot of wrong things have happened, and but they were not able to. The Ombudsman also asked, where is the 20% co-op in your policy? It was a United India policy. The group insurance was Dosa Medicare, with whom I had paid the premium. And
Little dosas.
Yeah, Dosa Medicare. Now this has happened. And I got the policy, the original policy, because even on United India's own admission, that the policy being is an old matter, the policy we are not having. They gave me the policy somewhere in 2023. Now, these wrong things have happened. The Ombudsman ultimately passed the order against me. They said that all these things are not allowed as per policy, but where is the policy? The policy even, I don't know whether Ombudsman has seen the policy or what. I have not seen. I saw the policy in 2023. In January 2023, I read...
No, you can't do anything about it.
You can't do it.
Because otherwise there will be no sanctity to any order passed. If it could be challenged at any time, it would have to be done within, appeal within the limitation period.
And now I can't go to the...
You can't do you can't go anywhere.
Even though the insurance company has...
No, you can't.
Terms and conditions laid
You can't.
You can't. Okay. Thank you so much.
Welcome.
And there is one second question, sir, is regarding the cataract surgery.
In that, the monofocals are allowed by the insurance company now, but the multifocal lens are not allowed.
They are allowed.
They are allowed? Okay. Thank you.
By mistake, due to slip of tongue, I said trifocal. Multifocals are allowed when I spoke.
Okay.
And people have got 2.5 lakhs, 2,75,000 even for multifocal lenses.
Okay. Thank you, sir.
Good evening, sir. Just one question regarding the Ombudsman. I was just handling my friend's case. It was not related to health though. It was related to a vehicle total loss. The policy, the IDV value of the car was 17 lakhs. The Ombudsman gave the award in favor of the customer. But the insurance company went against the Ombudsman. And now they have filed a writ petition in the High Court for this. So what I feel, the Ombudsman is like a toothless tiger because many of the companies are not willing to obey the award what has
That
been...
is seldom done, very seldom done. I don't think you'll even get 1% of the cases.
General insurance, which
it is just, it is
even
just...
after getting an award in favor of the customer, as you said, they go against the customer. But in this case, they have seen the merits of the case and they've given the award to the customer, but they have filed a writ petition in Bombay High Court against the Ombudsman and against the customer.
They are entitled to do that. They are entitled to do that. But it's maybe...
We should know that even the Ombudsman's award is not the final.
No, that's very much... Has the Bombay High Court admitted the petition?
It's in the process actually.
Because it may get thrown out at the initial stage also.
Because I think my friend is going to insist on giving 100% that...
it may get thrown out. It may get thrown out, but theoretically they have the right to challenge it.
Okay, so what this is a...
It's not appealable. It's not appealable, but you can go in writ.
Okay, so because I thought that Ombudsman is also like a toothless tiger. The company is not abiding by that award.
No.
Not the case normally. No? Okay, thank you.
Good evening, sir. See, in this insurance ombudsman, I mean, who can go there along with this family? Sometimes these policy holders may not be fully aware of these terms, conditions, and if he cannot represent, can he get the services of some specialists, some lawyers, or some?
No, lawyers are not allowed.
But except lawyer, some practicing person, some specialist.
Some allow, some don't allow. They want to hear the insurer himself.
Thank you, sir.
I think we can have just 2 more questions before we wind up.
Good evening, sir. My name is Jehangir Gai. One of my clients on January 4th had a surgery in Leelavati hospital. And in policy it was written to pay, you can go for any category of loan except the street room. So my client says, I would like to go for a super deluxe room. The company said, when we went to the TPA said, we had Niva policy only with a single private room. We can't give you deluxe room. So my client worked on me, my policy, I can go for a super deluxe also when you are not giving. Then I spoke to my senior people also in Niva, but they said, we can't, they do the mail and all that time also, they have not got any reply. But after 1 week, when Saif Ali has admitted in the same hospital with the same Niva policy, so he got a suite room also. When the TPA told me...
See, you may get the room, but whether you'll get the reimbursement is another question. I don't think Saif Ali requires reimbursement. So it depends. We'd have to see the terms of the policy.
But the company is saying in certain hospitals they only have
See, that is why I say, don't ask me specific questions, because without seeing the policy, I cannot comment.
Hi, this is Neha Shah here. I just wanted to check, there are people these days, the off-late, because of the inflation,
Because of the?
inflation, rising inflation in medical, this thing, fraternity and fratfield. They introduced the top-up policies, which are mostly economical. Now, when a person is buying a base policy from January certain year to January next year, and the proper policy is, bought in between somewhere March to March, okay. Do the gap of January to March, is it, when the claim arises, they deny on the ground that this is between, 1st January 25 to 26. And the other policies.
The top-up policy is available, so the date would not make any difference, except maybe during the first policy. Let's say your first policy is from 1st January, and your top-up policy begins on 1st March. Then for those 3 periods you are without any top-up policy. But otherwise later, both the policies are concurrently running.
So, like you are trying to say that will be running on a proportionate basis, like next year, January is
No, after exhausting the limit under a base policy.
No, not that way. Currently should be running. So this date should not matter, right?
Date should not matter.
But we are facing this problem of it from, with many cases.
In fact, normally what they try to do is...
insurance company is also not, we are the advisors, they are not hearing us anything.
Normally what they try to do is that they try to say that the top-up policy comes into play only after when the sum exceeds, the expenses exceed more than the base limit.
Okay.
But there is at least one very interesting judgment on this, that the insurance company has to pay it the moment it exceeds the limit of the base policy. Otherwise, normally in the top-up what they say, they put an equivalent of the base unit again. So if your base policy is 3 lakhs, then they say top-up policy will be effective.
So there is no problem with the base or the sum insurance.
But in the top-up they play mischief. In the top-up they play mischief, but there is a judgment of the National Commission on this.
So it should not matter second year onwards.
It should not matter.
Thank you.
So we landed here.
Just one more question since come.
So thank you for very educated for educating us. My question is on premiums are getting inflated because there is inflation. We all know that, but general inflation that we are seeing in economy is 7%. On medical side, it's greater than 14%. It's more than a double. And primary or one of the reason causing this inflation is because healthcare is not talking very well with insurance company. That's why we see inflated rate charges.
I'll tell you. Actually, what is happening is that a Mediclaim policy is economically unviable for the insurance company. Now, let's say if you pay a premium of 50,000 per year for 10 years, and then one bypass will be more than 5 lakhs. So that is why insurance companies are resorting to all these tactics. The original concept was that it is a measure of social welfare. It is not a profit-making policy, and there should be cross-subsidy from other sectors of insurance. But insurance companies want this to be also equally profitable, which can never happen.
But counter to that could be, if you get your probability calculations right, then you can still earn profit And
no, you can't. As I told you, the cost of healthcare is so high that the entire premium gets wiped out. Whatever you've paid for 10 years gets wiped out in a single hospitalization.
Thank you.
Okay?
Thank you, Mr. Gai, for taking the time to do the presentation today. Thank you for answering all the questions as well. I'm sure there are many questions that couldn't be answered because they were too specific, but you can always connect with Moneylife Foundation. You can talk to one of my colleagues and we will set you up a meeting or an email to counseling for the sessions. So thank you everyone for joining us today. I hope you enjoy the session. Have a good night.
Just let me get down and leave.